of the batch of 2020, as well as to their parents and all those who are present here who have played an important role in achieving this moment. I begin by giving my very warm regards and compliments to my distinguished colleague, Justice M.R. Shah, to Justice Arvind Kumar, the Chief Justice of the Gujarat High Court, judges of the Gujarat High Court, the Law Minister of the Gujarat government, Mr. Trivedi, members of the General Council, the Executive Council, and other governing bodies of the university, Professor S. Shantakumar, the faculty members, and to all the other dignitaries. Many thanks to GNLU for once again inviting me to speak at the convocation. I've always cherished my association with GNLU, and the Director's annual report is evidence of the continuous growth of the Institute and the incredible achievements which have been spurred by all of you in the faculty and amongst the students. I wish I could have attended the event in person at your excellent campus. However, I'm happy to connect with all of you virtually. Considering that your batch graduated just as the pandemic began, I'm sure that you are used to this new world of all of us becoming digital natives, with technology mediating our community and our personhood. However, I'm also sure that you are enjoying this opportunity to be once again physically with your batchmates. After all, I hope that for most of you, the 5 years of law school did not just provide you with legal education and the space to discover yourself, but also help you find companionship in friends, which will hopefully continue to be a lifelong source of joy. So I can only imagine how overwhelming it must be to get to be back in this space, which has been the source of all these fond memories after more than 2 years. Convocation speeches are always difficult because I do realize that I'm speaking to a crowd which is simultaneously dealing with complex emotions of happiness, accomplishment, nostalgia, and also a little bit of sadness. Unfortunately, my specialization tends to be more towards the area of law, lectures on which are generally believed to be drab, emotionless, and lectures which I believe you have received enough in your half a decade at law school. However, unlike the stoic image of law that is generally represented as a mark of a good judge or lawyer, I do want to begin my presentation by stating that the characterization of emotions as a force that warps and degrades judgment is incorrect. As critical legal scholars have explored through their scholarship over the past 2 decades, understanding emotion is an essential part of building a fairer and more effective system. While emotions may lead us astray, they also play a crucial role in sense-making and decision-making. Even the assumptions of emotions leading individuals astray have more frequently been applied to individuals and groups with a marginalized status, primarily individuals and groups lacking social, economic, educational, or political capital. So, unlike what many people would tell you is the norm in law, I would beseech you, at least on some occasions, to bear your hearts on your sleeves. Last weekend, at the All India District Legal Services Meet, which was organized by the National Legal Services Authority, I emphasized upon the importance of incorporating fourth and final year students of law in our legal aid programs, especially in mediation. One of the reasons I did so was because I felt that the students will do a much better job in mediating, which is a lot about managing emotions of parties, than lawyers who over the years become desensitized towards the trauma and emotions of parties involved in a case. In our profession, it is very easy over the years to forget that each case you are dealing with defines the trajectory of life of the individuals involved in that case, even though it may just be one of the multiple cases you are dealing with for that day. Therefore, one of the principal learnings which I have come across as a judge, first of the High Court and then of the Supreme Court, is there is no case which is too big, and certainly there is no case which is too small or too ordinary. This is why I want to re-emphasize that all these emotions you are feeling at your graduation are not only legitimate, but you should be proud of your amazing achievement. And I hope that as you sail through your careers, you will continue to stay in touch and be guided by your emotional side as well. I generally tend to begin my convocation addresses by welcoming the new graduates into our legal profession and discussing all that is ahead as they begin their careers in the diverse options that are now open to law students. However, with more than 2 years having passed since your graduation, you need no welcome, especially considering the tumultuous times in which you joined the legal profession. So today I congratulate you instead for completing 2 years in these uncertain times, and will talk about a few lessons that I have learned over time. Out of these, I hope some of my lessons will be of use to you as you continue to progress in your chosen careers. I hope the past couple of years have been enriching for each one of you, especially considering that the early years tend to be the most welcome in our profession. As you will realize in the long run, 2 years constitute a short time spent in the profession. When we were young, we tended to overstate the importance of the career choices we made and the long-term impact they will have. While I of course do not want to encourage you to make hasty decisions, I do want to reassure you that this is quite an early stage in your career, and it is perfectly okay to be confused about the paths you have ahead and the choices that you want to make. Considering the various choices that the privilege of an education from a top-tier national law university, such as GNLU, opens, it would be scary if you were to make your entire life planned out at such an early stage. Personally, speaking for myself, I did not even have plans to pursue law after finishing my undergraduate degree from St. Stephen's College in economics honors. Having battled the doubts of my admissions interview panel, which was skeptical about my ability to pursue economics and mathematics in the first place, I graduated at the first position in first class in the university. I was all set to pursue a master's degree in the field. However, I seem to have ended up taking a lesson from the movie 3 Idiots on attending classes just for knowledge, much before the movie came out, and ended up sitting through some of the classes of Campus Law Center in the break before my economics master's degree. Riveted by the way law was taught, intertwining questions of policy and constitutional morality with the quest for liberty and freedom, a feeling I hope many of you can relate to, I ended up making the career-altering choice of pursuing the law. In my early days, after I returned to the bar, upon completing my doctoral studies at Harvard Law School, I had moments of doubt. I had returned to India in preference to a high-paying job at a Wall Street law firm. My first brief for mentioning a case for listing yielded a docket fee of 5 GMs. Though we marked our fees in GMs, there were no real gold mohurs which came to counsel. My fee of 5 GMs translated into all of 75 rupees. A Harvard degree notwithstanding, that was how the market for legal services priced my worth. The reason I'm sharing this story is to let all of you know that life is much more a series of accidents than a linear, planned event. And it is always okay to take your time to explore. All choices you make are worthwhile choices, and there is no single way to use your law degree. As it is said, there is no curriculum to life. At every stage, life is an elective. In spite of whatever you choose, and especially in litigation, I think an important skill that you only learn over time is the importance of knowing when to speak, of knowing how to listen, and when it is in the benefit of your client and yourself to stay quiet. I'm reminded of my younger days as a lawyer in the Bombay High Court, where I was representing a public sector undertaking, which unfortunately that day had no case at all. So I stood there with my head bowed down, as I knew that the second I would have to open my mouth, I would have had to confess before the bench that I had no case. However, my learned friend representing the other side kept interrupting the bench, talking over them, and needlessly arguing beyond a point to such an extent that the judge was so riled up that we ended up receiving an order in our favor. When the other side filed a letters patent appeal, such was my case that before anyone spoke, the distinguished Judge Justice M.L. Painse asked me, "Mr. Chandrachud, what did you even argue for this order to have been passed in your favor?" Of course, I was too young then to respond cheekily, but you all know the answer now. What Aaron Burr advises Hamilton in the famous musical is probably a good idea in such contexts. And he says, talk less, smile more. Don't let them know what you're against or what you're for. But of course, in all other contexts, and in more instances than less, it is also important to speak up and ignore this advice. After all, Hamilton would have probably never had the success he did had he decided to be docile and silence the strong and insightful voice that led to his success. And I hope many of you will follow this path. Outside the world of litigation and in the world of social justice, the respectability politics that Burr advocates, that is, the belief that marginalized communities must adhere to dominant cultural norms to receive respect, has received a fair amount of criticism. Much before the term respectability politics was coined, the famous sociologist W.B. Du Bois, in his pioneering work, diagnosed the issue of double consciousness for marginalized groups, which such adherence only furthers. As Iris Young discusses, cultural imperialism is one of the phases of oppression faced by marginalized groups, and she notes how the dominant culture will always define such groups as deviant and would fail to represent the group's experiences regardless of the manner in which the group may behave. In other words, respectability politics may sometimes even lead to further marginalization of subgroups. This brings me to my next piece of advice, which is drawn from Professor Quigley's letter to a law student interested in social justice, which I think is applicable to all law students. Remember to not confuse law and justice. A lot of work which leads to achieving justice within law also happens outside the law in terms of social movements, shaping politics, and cultural understanding. In our own context, we don't have to look too far to decipher the difference between law and justice. It was only in 2005 that women were granted interest in co-partnership property and were given equality in terms of succession to property. Until the longest time in our history, there was no legislation regulating child labor. Minimum wages across the world are a result of recent labor movements. During your own time at law school, Section 377 of the Indian Penal Code, which criminalized sexual relations even between consenting adults of the same gender, was the law of the land. It was only in Navtej Singh Johar versus Union of India, a bench that I was a part of, that the Supreme Court held that Section 377 was unconstitutional, as it violated the right to equality, non-discrimination, and life, and went on to provide an expansive affirmation of the rights of LGBTQ individuals. All these issues existed simultaneously with the institutions of law. However, we now agree that they were unjust. There continue to be laws as well as lack of regulations which push the marginalized deeper into the pockets of marginalization. At many points in your career, you will realize that what is legal is probably unjust, whereas what is just may not be always legal. However, this is where your law school training of learning to critique the law will come in handy. I hope many of you will either pursue a career or have opportunities in your career to participate in working towards social justice and furthering rights. Of course, I understand that pursuing such a career trajectory is not for everyone. In fact, for many, the low pay which accompanies such practice not only makes rights litigation an unlikely but an impossible choice. Many students come from impoverished backgrounds. They or their families may have taken loans to fund university education. They are compelled to take high-paying jobs to pay off their loans. For many students from marginalized backgrounds, financially lucrative jobs bring social mobility. But one can promote constitutional values and social justice if you imbibe constitutional morality in the way you conduct your professional life, regardless of the career which you pursue. At all junctures, where you do have the opportunity of working towards social justice and furthering rights in small and big ways, you must remember the importance of differentiating between law and justice and critiquing the law as a step to advance justice. Niti, in other words, does not always result in nyaya. Of course, you will encounter people who will tell you the situation is much better than before or better than the situation in other places. However, the journey to justice does not stop at a midpoint or where we feel that we are finally being less unjust than the others. Along with this critique, it is important to simultaneously look for the ways in which laws can be reimagined and redefined to make them better and more just. The reinterpretation of law takes place as much through the lawyer's vision as through the judge's craft. In this process, as well as in anything you do in life, you will have moments of doubt. And sometimes, when you confront failure, the more exciting and adventurous paths you choose in life, the more probable failure becomes. So always remember to not be afraid of failure. As a matter of fact, if you're not trying to achieve things when you are falling, you are probably not even trying to meet your potential, because it is only at that edge where you will receive equal amounts of success and failure. Moreover, especially in our profession, it may not be even a sign of that, but just sheer bad luck. And if you are in the space of social lawyering, always remember that never has justice been achieved in any movement without encountering failure, criticism, or chaos. It also helps to remember, especially in the world of social media, with limited attention spans, that a lot of work we do will only have long-term impact, and that you should not worry too much about the everyday distractions that will become a given in your path. Seth Godin talks about this beautifully, using the analogy of the current and the wind, and I quote him, "The wind gets all the attention. The wind howls and the wind gusts, but the wind is light. The current, on the other hand, is persistent and heavy. On a river, it's the current that will move the canoe far more than the wind will. But the wind distracts us. Back on land, the current looks like the educational industrial complex, or the network effect, or the ratchet of Moore's law, and the cultural trends that last for decades. The current is our persistent systems of class and race and gender, and the powerful industrial economy. And if I may add, in our context, caste as well. It can be overcome, but it takes focused effort. On the other hand, the wind is the breaking news of the moment, the latest social media sensation, and the thin layer of hype that surrounds us. It might be a useful distraction, but our real work lies in overcoming the current or changing it. It helps to see it first and to ignore the wind when we can. This quotation is especially relevant to remember in today's world, with polarizing opinions and conflicting actions. Legitimizing and balancing thought can only be termed as a grave responsibility of each citizen, young and old. The words famously attributed to Voltaire, "I disapprove of what you say, but I will defend to death your right to say it," must be incorporated into our being. Make no mistake, being accepting and tolerant of the opinions of others by no means translates into blind conformity, and it does not mean not standing up against hate speech. Stepping into the world as fresh graduates amidst the increasing noise and confusion of political, social, and moral clashes of ideology, you must be guided by the path of your own conscience and equitable reason. Speak truth to power. Maintain your composure in the face of unspeakable social injustices, and utilize your good fortune and privileged positions to remedy them. It may seem idealistic, but as young, wide-eyed graduates, you must aspire to attain utopia, for the harbingers of change are often hopeless dreamers. As new lawyers, your education has entrusted in you the power to discern the right from the wrong, the power to identify that glimmering speck of justice hidden within voluminous court records, the power to influence positive and constructive thought through the rigors of academia, or the power to bolster the economy, generate employment, and create better working conditions in the corporate sphere. No matter what path in law you choose after graduation, this profession enables you to create a world that uplifts the collective along with the individual and to assist the disenfranchised. I would like to again thank the director for inviting me to speak on this occasion. I once again congratulate all the graduating students and wish them success in all their endeavors and a lot of strength for battling all the challenges on the path to success. Professor Chandrachud and your team, I'm so grateful to you for having invited me to speak on this occasion. Namaste.